This is Michael Cowen, and welcome to Trial Lawyer Nation.
You are the leader in the courtroom, and you want the jury to be looking to you for the answers.
When you figure out your theory, never deviate.
You want the facts to be consistent, complete, and credible.
The defense has no problem running out the clock. Delay is the friend of the defense.
It's tough to grow a firm by trying to hold on and micromanage.
You've got to front load a simple structure for jurors to be able to hold on to.
What types of creative things can we do as lawyers, even though we don't have a trial setting?
Whatever you've got to do to make it real, you've got to do to make it real. But the person who needs convincing is you.
Welcome to the award-winning podcast, Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Trial Lawyer Nation is brought to you by LawPods. LawPods is the company that produces these podcasts. They make my life so easy. All I have to do is show up and talk, and they do all the recording, making sure it sounds good, the editing, the putting out clips for social media. If you are thinking about doing your own podcast, I highly recommend LawPods. We're going to start a new feature on this podcast. It's Ask Michael and Mallory Anything. If you have anything you'd like to ask either Mallory or me, we're going to start doing an episode every couple months where we're going to answer your questions. So just send them in to me at michael@cowenlaw.com, and Mallory and I will answer them. Anything from, legal strategy, marketing management, anything else in life you want to talk about, we'll be glad to talk about it with you. Again, Ask Michael and Mallory Anything. Just send us an email. We'll be glad to answer your questions. Today on Trial Lawyer Nation, I am joined by my friend and a brilliant visual trial strategist, Amy Hall. Amy, how are you doing today?
I'm doing great, Michael. So great to see you again.
It's great to see you. I'm looking so forward to seeing you in Napa later this year. We're going to get to work together a couple times for some work sessions on our cases.
Yeah, I'm very excited about that.
Yeah, you've done so much for my firm and how we work up cases and created so much value that I really wanted to get you back on the podcast and learn some more from you and share what you know with our listeners. So, Amy, for those who didn't listen to the last episode 2 years ago, let's just get a little bit of background. So tell us a little bit about who you are and what you do.
Well, I'm a visual trial strategist. I've been doing this for over 18 years now. My background it really led me right into this line of work. Graphic design, probably not a huge surprise, is my early training, my early business experience. I worked for a lot of different industries, including the gambling industry, which sounds so out of left field until you think about it for a second. And when you think about decision-making and emotions and attention and how that industry has really dialed that in. So that was training I didn't realize that I was having for working for plaintiffs' lawyers, but such as it is. And I worked for a lot of companies all over the world. And then I met the visual trial strategist, Rodney Jew, a very accomplished litigation strategist. By the time I met him, he and I hit the ground running. I didn't realize that this line of work was what all my skills had been moving towards my entire professional career. And we had so much fun together. And we worked together side by side for over 13 years. And then a funny thing happened on the way to the future, the COVID-19 pandemic. There were a lot of shifts that happened, and Rodney stepped back from doing the trial strategy, and I stepped forward. And now this is what I'm doing every week in, week out. I work with a different firm every week on a different case, and it's been keeping me very busy.
So what is visual trial strategy?
Visual trial strategy is a way to connect with jurors. I mean, plain and simple. Lawyers spend a lot of time on strategy and the writing, and it sounds fantastic, but it's in the fishbowl, this world where it's lawyers talking to lawyers. So it's like an echo chamber. Being in trial, it's like storytelling on steroids. If it doesn't land with the jury, if they cannot understand, remember, and care about your case, it's all for naught. So great strategy, great legal theory, great writing, but if it doesn't connect with jurors, you're not going to get their vote, either in liability or in damages. So all people, and jurors are people too, are visual creatures. We are, as human beings, primarily visual. So that's the clue. That's where we can create a story that sticks, where we can simplify and distill, and when people can see what the case is about, and it doesn't matter what the case is about. I'm completely case agnostic. This works for every kind of case. When they can see what a case is about and see it distilled simply, then they feel empowered, then they can give their vote. So that's the entire basis for visual trial strategy. And that's what I do, taking a case apart, a super amazing case that lawyers may have worked on for quite some time, and how do we distill it for lay people so that when they see it, they can understand, learn, remember, and care about it.
Yeah, I remember before I worked with you, I was doing a focus group. And I remember when I was watching the deliberations, which drives me nuts. And one of the focus group members was like, well, they never said anything about this. And I was like, damn it, I said that 5 times, but they didn't remember it because people don't necessarily remember spoken word. I mean, you're hearing so many, a juror's sitting there all day, for hours, hearing people talk. Some courts allow notes, some don't, but trying to remember everything said in a week-long trial, it's just really hard to get it in. And you have to really, focus on what are the points you really want them to get. And then I think, how do you get them to do it? So how do we use visuals then to get people to remember our points and to be more persuasive in our cases?
Yeah, you've hit upon 2 great things in your observations. So one is memory. Memory is really important because, again, you're saying all these really great things, but if they don't remember them, and we just assume that the jury is just this tabula rasa, they're just this empty vessel that we're just filling up with all our great ideas, and then they're just going to remember it all and connect all the dots. They don't remember. But what you're saying is also revealing something even more fundamental is they're not paying attention. And that hurts the heart when lawyers hear that. They're like, what? But I'm so compelling and I've been working on my delivery and this case is really, really interesting. And all those things are true, of course. But people tune in and out. It's a very natural human mental process that people can only pay attention to things for sustained attention about 10 minutes at a time. And that's really at the outside. There's been a lot of studies that show that attention span is even getting shorter because of the influence of social media and the way even TV is timed now with a lot of quick cuts, that attention spans are getting shorter. So if they're not paying attention, their attention is moving in and out. Even if you're really interesting, you may say something that makes them think about, oh yeah, I got to do grocery shopping for dinner tonight. And then they tune back in and then you're talking about something else. So they're trying to connect the dots with where they left off, with what they're reconnecting with. And they're going to fill in with their own ideas about things. They're called filling defects. So that's a lot of mental time that the jury is involved in that you're not privy to. They're sitting there, they're nodding and smiling, but you don't know what they're thinking about. So there's a principle called the pictorial superiority effect, fancy name, simple concept, that people remember what they see a lot more than they remember just what they hear. So you have the opportunity to merge an image, something visual, with what you're saying, and their memory will soar. 3 days later, people remember 3 to 4 times more of what they see and hear than just what they hear. So attention and memory.
Yeah, and if you look at the studies, and if you only use spoken word, the percentage retained is so tiny. It is really depressing, actually. But it also means we need to use, whenever we can, we need to use the right visuals. No, yeah, I remember what I was saying. Even I have a much shorter attention span, as I just proved. Couldn't even remember my own thought. I have lawyers that want to tell me about a case, and they're coming to me with a question, but then they want to give me every irrelevant detail about the case. I'm like, hey, what do I need to know? What do you want me to answer? And what do I need to know to answer? I don't need to know every fact. I don't need to know. It drives me nuts. And so I'm figuring if it drives me nuts, and maybe I have a little bit of adult onset ADD or something. But if it drives me nuts, I'm used to being able to watch a TikTok video to, 2 minutes at most. It's got to drive the jurors nuts to sit there for day after day. They have to be zoning out.
They absolutely are. Even if it's super duper interesting, I promise they are zoning in and out. It's just the way the human mind works. It's like when you work out and you're pumping iron, like you can do 10 bicep curls and that 10th one's really hard because cells need a break. They can't just sustain energy indefinitely. Your neurons are cells too. They work the same way. The brain is unbelievably complex. It's very powerful. But in terms of sustained attention, we're not that great at that. And that's why visuals are so good. You hit upon something else, and it's that distillation. So visual trial strategy is not about just making visuals. That's why it's visual trial strategy. If it was just about slinging graphics and then we could call it a day, where would the strategy be in that? There wouldn't be. It's not just about slinging graphics. There is this instinct that lawyers have to add. Like, well, let me show you this. Let me tell you that. And this is just as important as those last 20 things I was telling you. And they may feel equally important because one of my catchphrases that is so true is that lawyers have the curse of knowledge. You know so much about your case. You have so much general knowledge. You've been working on your case for years. It may all seem equally important. I guarantee it's not. So the visual trial strategy process distills your case into what are truly the takeaways, the high points of the story that jurors must understand, remember, and care about to give you their vote. There may be a lot of supporting facts, but they're not all equally important. And that comes through in the visual trial strategy process. Distill, distill, distill. And when you think you've distilled enough, distill some more. It's a labor-intensive process, but you'll find that everything you do to help the jury is going to help you. It's going to help your case. It's going to make your understanding of it more powerful.
Absolutely. And that curse of knowledge is such a big thing because, we'll often work on a case for 1 to 3 years before it gets to trial, in some states even longer. And a lot of times you've had a fight over something and you've really tried hard to get this piece of evidence. You've had all these discovery fights. And at the time, it seemed like it meant a lot to you, given everything else you know. But when you put the case together, it just ends up not being that important. And you either should be something that it's a cherry on the top of the sundae, or maybe it's just not worth putting in at all. And I think one thing I've enjoyed about working with a visual trial strategist like you is that you don't come in with a curse of knowledge. You come in not knowing very much at all about the case. And so then we have to create it where you will understand it because a juror's coming in knowing nothing about the case. And so that the case has to actually make sense to someone that is just hearing it for the first time. And I've seen that. I've seen lawyers, they're starting their opening statement and they're starting off by trying to counterpunch from the punches they know the defense is going to give in 30 minutes, and the juror doesn't even know what the story is. It's so confusing because you're trying to defend against something that hasn't been said yet without giving your own point, and it just gets really, really confusing. And I think when you do the visual trial strategy, because it's all in pictures, it has to be step by step, make sense from the beginning, and then what is my story? I'm not worried about their story so much. I'm worried about mine.
Absolutely. Yeah, that's a really good point. In opening, that's your opportunity to plant your flag. You get to go first. If you're the plaintiff's lawyer, you get to go first. That is such a powerful position. And sometimes I do think it's squandered, that already getting hackles up, ready to fight. And that's an instinct that's very common in trial lawyers. I mean, hey, you fight for a living. But don't let that instinct overwhelm what jurors need to understand, learn, remember, and care about your case. So you're absolutely right. When I come in to work on a case, I purposefully almost hobble myself. Lawyers always send me everything, expert reports, and here's a lot of evidence, and here's a big folder of photos, and here's a bunch of pleadings and motions. And I purposefully don't look at that material before we work on the case. There's only 2 things that I ask the lawyers to send me, and I recommend that all trial lawyers do this on every case they work on, regardless of whether they work with me or not. 1 is to create your 2-page neutral statement. 2 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 is to create your 2-page neutral statement 2 pages double spaced, regular type, not like tiny type, neutral statement. In other words, like a God's eye view. It's what happened? What happened? And what are the claims from both sides? Like really make it neutral. It's very, very hard to do, to make it neutral for trial lawyers. And it's very hard to distill it to 2 pages. And lawyers tell me, oh, no, this case is super complex. You don't understand. This one cannot be distilled to 2 pages. And I say, keep trying, because that very process will really help get rid of all the chaff that seems really important. Like what you said, when you get to trial and you've been working really hard, you fought really hard to get this one piece of evidence in. Or what I see a lot, you pay a firm, maybe 30 grand to make an animation or a movie. And it's like, oh man, look at this thing. It's so great. It's got the fly-throughs and like the wheel is flying off. It's amazing. It looks so good. You paid so much money for it. You're like, well, we have to use it. And we see through the distillation, through the visual trial strategy process, it's like, well, actually, is this a video for the defense? Because this isn't really going to help your case. Yeah, but we paid so much money for it. We fought so hard to get it. We got to use it. You do not got to use it. Put it on the cutting room floor. You don't need it. It's a very, very painful process.
Yeah, I've spent a lot of money on things I ended up not using. I've got like a 2-sentence saying on cases. The first sentence is a plaintiff cannot win a complex case. If it's really complicated, that's defense territory. Because if it's that complicated, how are juries going to get outraged that the defendant made the wrong decision? If it's that complicated, then, people are just doing their best. There's multiple decisions you can make. But the corollary of that is every case is a simple case if you know it well enough. I mean,
wow, that is so cool.
There's a famous, yeah. I have to come up with something I've copied so many things from other people. I talk about, if you chase 2 rabbits, you only catch one. I mean, it's all kinds of Rodney sayings. Well, I have that little card deck Rodney used to give out, so I use the Rodney sayings all the time. But I got to come up with a few of my own over the years. But really and truly, like it goes back to there's a famous case, Pennzoil versus Texaco. One of the great trial lawyers, Joe Jamel. It was a really complicated, supposedly, case over oil rights and whether a contract was enforceable or not, and it involved billions of dollars. And he distilled the case down to, does a handshake mean anything? They had a handshake deal. Was that a contract? Not. So the whole thing, the case was, does a handshake mean anything? And if it does, this is a deal. I mean, that makes sense. Hey, they shook on it. That's a deal. I'm getting ready to try one. It's, the other thing I got this, I think I got it from Michael Leserman. It's, this case is simple because blank. This case is important because blank.
Wow. I like that a lot.
The case I'm getting ready to try. This case is simple because it's dangerous to back a tractor trailer across a roadway at night. This case is important because if the jury doesn't do something, more people are going to get killed by tractor trailers backing across the roadway at night. A little long. I wanted to see if I can get a little shorter.
Sure.
I won't necessarily say those. I won't say those words necessarily to the jury, but it focuses where we're going, and then we create the visual strategy to tell the story to back it up to why is this dangerous? Why did the company know? Those kind of things. Why is it the standard not to do this?
That's really powerful. And I'm going to steal that too. Michael is really awesome trial lawyer, and as are you. And I like it because a couple things. One, it's a very clear distillation. And maybe you do just use those statements straight out. This case is simple because, this case is important because. It is telling the jury right away, point blank, this case is simple. It's like, oh, what a relief. I'm so glad to hear that. And that phrase is followed immediately by a super powerful word, because. Because is one of those very, very powerful words. When people hear because, their mind automatically orients itself to saying, oh, here's the reason why this thing is true. So it primes them to think this is meaningful evidence. Because means whatever comes behind the word because is going to be something persuasive. I like that a lot.
So what are the different, kinds of visuals that are often useful in getting ready for trial?
It's interesting that no matter what kind of case I work on, there are common exhibits that are common to every kind of case, whether it's a giant mass tort or a slip and fall. And again, I'm completely case agnostic. The process works equally well regardless of the size of the case or the complexity of the case. And first and foremost, there's the formula. And I know we talked about this the last time that we were on this podcast together, that the formula is your shot across the bow. It's your elevator pitch. It's the very first exhibit that you show, or suite of exhibits that you show the jury. And it's the very first exhibits that you create, because it distills the neutral statement, which I just described, into a 3-move exhibit suite. So these would be boards. I'm a big proponent of boards, and I can talk a lot about that. You have your anchor plus your link equals your payoff. Okay, so what's an anchor? An anchor is something that's unassailably true. So like the purpose of trucking safety regulations is to prevent crashes, something like that. That's the purpose of those things. That might be a little unwieldy. Maybe we would edit that down, but that would be something that even the other side would be like, well, yeah, I mean, I guess that's true. How could that not be true? Plus the link. The link is if a trucking company doesn't follow safety regulations, what does that equal? That equals somebody's going to get hurt. So we build that formula in every single case. And then we make it specific to the facts of this case, the trucking company that we're going after, for instance, the plaintiff that was harmed in this case. And right off the bat, it's like you were describing Leserman's simple phrase, this case is simple because, this case is important because. I love that. The formula does that. It shows the jury right off the bat, this case is simple. There's just 3 big buckets. And there's going to be a lot of details that are going to go in each bucket. But right off the bat, the jury can sit back and say, oh, thank goodness. I only have to think about 3 big things. Sure, I'm going to learn a bunch as we go along, but this case is so simple. And it earns juror trust right away, because the other side is going to go get up there, throw spaghetti against the wall. They want to see what sticks. They're going to counterpunch on things big and little, and they're going to look like the ones who are trying to obfuscate, the ones who are trying to make things complicated and messy. And you're going to say, no, you're just there. You've planted your flag. This case is simple. So that is a very universal exhibit. Now, that's the alpha. The omega of liability is your jury instructions. So there's a lot of stuff that comes in between, timelines, evidence, talk bubbles, which is what we call boards that show deposition testimony of, plaintiff, liability, and defendant. And we put them in, we call it talk bubbles, sort of like you would see in a comic strip, where there's a little bubble coming out of their mouth, and we quote verbatim from the transcript. It's a very powerful way to let people pause and reflect on important testimony. So there's a lot that's going to come in between, but then the omega of liability is jury instructions, which are super complicated and are written by lawyers. And when jurors see that, their eyes glaze over and they think, oh no, I've been assured that this case is simple all along. And now here I am with my instruction booklet for how to decide. And I have absolutely no idea what any of this stuff means. I have no idea how to interpret this in light of everything I've been taught. So I see that as a place where sometimes lawyers drop the ball. You have to teach the jury instructions, interpret it into English, like regular people language, and then apply it to the facts of this case. What does negligence mean in this case? Well, I'll show you. This is how you know what negligence is. This is what it looks like in this case. That's the opportunity to put a bow on it before the jury goes back to talk amongst themselves.
I think another, we always talk about opening and closing and all the times the lawyers are speaking. I think another time that the visual trial strategy is so important is when we put on our own experts. Because I think as by default, anyone being paid money to talk has zero credibility. So when we use, and you something I learned from you is called a document deconstruction or document decon, but when we use visuals to show that the expert is basing the opinion on reliable science, reliable standards, the actual evidence in the case, rather than the expert just saying it like, well, take my word for it because I'm charming and good looking and can testify well. I think it's so much more persuasive.
Yeah. Yeah. The battle of the experts, like you said, each side is going to have their experts. Everybody knows they're paid to be there. They almost like cancel each other out. They have the potential to. If you ask an expert what time it is, they're going to tell you how to build a clock. So I never let an expert not have visuals. So never let them just talk and be a talking head, because nobody's going to understand and really nobody's going to believe. And secondly, never let an expert bring their own exhibits. No, because they talk about the curse of knowledge. Whatever their line of specialty is, they know it so well, and they're very, very proud of that knowledge, and they want to make sure everybody in the room knows how much they know about stuff. They think that adding more like knowledge nuggets is going to really impress people, and that people will just sort of like sit down and say, okay, fine, whatever that guy says. It's not the way it works. The rules of distillation and simplification work even more when experts get up to testify. So if they can't bring their own exhibits and you don't want them to just talk, that means you've got to make the exhibits for them. So you do it based on their report. You do it with their the iterative process with them. You show them, create a series of exhibits based on the report, saying, is this what your report is saying? And they say, well, not quite. This gives you a chance to understand what they're going to testify about even better. Because if you can't make it understandable to a regular person and still be true to what the expert's trying to communicate, then the jury is not going to get it. So going through that process is going to help the jury. And then, when the expert gets up on the stand, you ask them to say, Dr. McGillicuddy, did these exhibits fairly reflect what's in your report? Yes, they do. Did we work together to prepare these? And these are 100% what your report is about? Yes, they are. So even though the style will be contiguous throughout your entire presentation, which is good for jurors, they love that consistency, the expert will testify that these are something that the expert prepared, with your assistance, that are reflective of their report.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. And now, back to the show.
And then I think it's important to only hire experts who will work on that process with you. I mean, we start before the reports are written, not necessarily creating the visuals, but making sure, what are you basing your opinions on? To the extent there are some obscure areas where there's really no written standards, but most of the time there are some kind of written standards somewhere, some kind of literature somewhere. So can you base your opinion on it? And which is what the federal courts want, in Daubert and stuff. If you want your experts to actually be able to testify and you want to keep your verdict on appeal, it's what the courts want you to do anyway. And it just makes it so much easier because it makes them explain step by step, because they also come into that curse of knowledge. But it makes them explain the concept step by step, showing that they're not just making it up, but it's coming from somewhere. And, one of my other things I like to say is that you can't cross-examine a book. Say our expert counters our expert and their experts, they cancel each other out. But if we have like a book or literature or something that's left over, well, that's what the jury's going to believe. Yeah, I just always assume that if I don't have a really good, unless the expert's saying something a juror already agrees with, I don't think it's very persuasive unless it's really backed up by some unimpeachable source.
Yeah, absolutely. You need a lot of great sourcing. And that's an opportunity for you to really elevate that sourcing, those authoritative sources that the expert is basing their report on. Sometimes I see reports and there's so many sources. I'm like, whoa, what is all this? And see, like, what are the real high points? We make exhibits out of those. And so now you really put meat on the bones of what your expert is testifying about, because jurors love authoritative sources. They love, this is established, this has been proven, this is something that we know, and that's safe harbor for jurors. So that's stuff that you really want to like slow down and spend time with. You don't just gloss over and say, oh, there's this thing that was established in the 70s and take my word for it. Show it to them. Say, this has been true since the 70s. Let me show you more about that. Take that time, because that really makes jurors have the confidence that, like, oh, I'm understanding this, and it's something that I can plant my feet on.
And, using that document deconstruction a lot of times is just a lot easier and more persuasive than actually just, because you can just pull out the actual source and put it under an ELMO or an IPEVO, but then you've got all the text. I mean, I like the fact that you have like where it's coming from. So you got a picture of the actual source. You have a subject. What are we talking about? So it could be like, truck drivers, and then a question: what must they do before they turn left, or to make a safe left turn? And then you can have a picture of the commercial driver's license manual, and then you can have like the excerpt out from it, and then you can have your gloss on it in there. But it just really, it's like, okay, we know where it comes from, but then here we know exactly what to look for in it.
Exactly what to look for, because there's always going to be a bunch of chaff. There's always going to be a bunch of extraneous stuff, and when you put things up on an ELMO, there's going to be all this extra stuff. People, their minds are curious. They can't help but just kind of read all the other stuff, and there it is. So when you just pull the quote that you want them to see, and you show the little picture of the document, just like you said, it's there, and we cite it at the bottom, and we label it so people know what it's from. Gives them that confidence. Again, it's like a gut feeling. Okay, this is real, and this is the part that is relevant. And then we always pair that with what I call a chatty yellow box, which is a takeaway, because even really good authoritative sources are often written in this highfalutin language that people are like, wow, there's a lot of code words, a lot of technical jargon in there. I'm not sure what I'm looking at. Have the quote, and then in plain language below, just put the simple takeaway, what the material is. And you pointed out something that's really important, is that open-ended question at the top. Open-ended, so a who, what, when, where, why, how question. What do you need to know? What does the literature say? What do we know about X, Y, Z? It's open-ended. And again, like just like on an ELMO, jurors can't help but like try to figure stuff out they want to see. They can't help but go into the exhibit to find the answer. I want to tell you, because it's on point with this open-ended question. I'm obsessed with open-ended questions. Jurors like to ask yes/no questions. I'm obsessed with steering that instinct into open-ended questions for juries. Lawyers are afraid of asking open-ended questions because they're afraid, like, well, what if they come up with a line of thought that isn't what I want them to have? That's your job as the lawyer. But when you empower the jury to have that kind of intellectual freedom and emotional freedom to look at what you're showing them and come to their own conclusions, they will love you for it. I just read about some research from World War II, and that's what's so neat about visual trial strategy. It's not newfangled. It's relying on principles that were established millennia ago when the human brain evolved. It's stuff that we know about how the brain works. There was a study during World War II. It's called the sweetbreads study. So now if you're a foodie, you know that sweetbreads are neither sweet nor bread. They're organ meats and like glands and stuff that like the American palate is really not that into. So the US government wanted to figure out how to get American housewives to use more sweetbreads in their cooking so that meat could be preserved for the war effort. How do you get American housewives to cook more sweetbreads, more offal? What do you call offal? And what they found is, it is offal. It's very well named. How on earth could you convince women housewives at that time were doing most of the cooking? How do you convince them to do that? So they split the study into two groups. One group, they received a lecture about why it was important, how to prepare it, what the benefits were, all the stuff. So it was like a very didactic lecture. So that group listened. The other group was encouraged to come up with their own reasons for why it would be important to use sweetbreads. So they were encouraged to solve the problem themselves. So what's the takeaway from the study? Later, when they followed up with these groups, the group that came up with their own solutions They 37% of that group were now using sweetbreads in their home cooking. The other group, the group that just passively sat and listened to all the reasons, like, I'm the boss, I'm going to show you all the good reasons, that group, 3%. 3%. So when people when they feel that they're coming up with the answers themselves, they're so much more invested. They remember and care about it a lot more. They are orders of magnitude more likely to give you their vote. So lawyers like to be the smartest person in the room. You typically are. But the storytelling on steroids that is a trial, that's your opportunity to really connect with the people who are going to give you their vote.
Absolutely. There's actually studies showing that jurors fight much harder for a conclusion they came up with on their own than one that you gave them.
Exactly.
And
That's
so
very well said.
My goal is that every time, but before either I or my expert give a conclusion, I want the juror's reaction to be, no shit, Sherlock. I knew that.
Yeah.
The whole point is leading them down the path where they make that conclusion by giving them the facts.
Absolutely.
So I want to talk about a different kind of visual. We talked a little bit about the formula. I brought up the document decon. You also do a lot of work with timelines. I've seen some really good timelines, and I've seen some horrible timelines. And unfortunately, some of the timeline programs that are commercially available, they just make it really hard to understand anything or read anything. So what's some tips you can give us on timelines?
Yeah, timelines are important for most cases. I would say at least 90% of the cases I work on involve a timeline, because there was a time in the midst of history when this harm had not befallen the plaintiff. That's when stuff was happening. Decisions were being made by the defendant that were putting wheels into motion, sometimes quite literally. And how do we connect those dots to show that this resulting harm happened because of something that happened far back in time? So, kind of my rhythm and refrain here of distilling and simplifying. If you confuse a jury, you lose a jury. And there, like we've been talking about, there's this instinct to say, well, yeah, let me show you this and let me tell you that everything is so important and everything is equally important. You may have more than one timeline in a case. So right away, you have freedom to start separating different kinds of information. Often, even a very complex case can be distilled into one timeline. It's a painful process because things get left off the timeline that you think are so important. You do have the opportunity to make multiple timelines based on different sets of information. So decisions made by the defendant that were not known to the public, like the hidden stuff. So that could be a timeline versus the things that they did that were knowable, for instance. You have to distill so that, first of all, everything has to be legible. So there's an urge to we can cram more stuff in if we make the font smaller. If you make the font smaller and smaller, then people won't be able to read it. And if they have to strain to read it, then they're going to tune out. So you have to find the high points and you put them in very simple language. So say you have a very interesting piece of information that needs to go on the timeline. You can't explain it in 50 words. You have to explain it in about 10 words. You think, well, I can't. It's too complex. Well, that's why you have exhibits that are keyed to each point on the timeline. So if you can distill an event into just almost I call it like a fortune cookie, just a very simple phrase that encapsulates the takeaway, then from that you could say, ladies and gentlemen, see what happened in July? Let me show you this. You put up another board that then you can really drill down on what the timeline, that niblet on the timeline needs to teach. There's got to be a takeaway that comes from all the information.
What do you think the best time is in the life of a case to start working on the visual trial strategy?
I think you know what I'm going to say. At the beginning, like before you even file the case, and I can hear trial lawyers going, "Oh no, just one more thing I have to do." But don't think of visual trial strategy as something on top of what you're doing. If it becomes part of your process, it is going to make less work for you because your work is going to be very focused. distilling for the jury is going to distill your effort to the most powerful thing. So it actually makes for less wheel spinning and less blind alleys. So it's not adding one more thing. You begin the process yourself on the backside of a napkin. You don't need any fancy graphics software. You don't even need a fancy graphics person. That, like the formula exhibit that I just described, those are just words, very simple words with a plus and an equal sign. You can do that on your legal pad with just your nice fountain pen. And if you start that process, you are going to eliminate a lot of blind alleys. So you start it right away. Are they going to be finished exhibits right away? Of course not. But you're going to identify what you need to teach the jury. And if you do that, later you can get some graphics person on board to help you create finished exhibits. But it's that identification of what the jury needs for them to give you their vote that really needs to happen straight away at case intake.
Yeah, really and truly, like spending time early before you start taking depositions to figure out, what are the rules that are going to apply in this case? What are the sources of those rules that I can use? Are these things that so you ask them before, you can ask people discovery. Are you aware of this? Have you heard of this? Is this important for these reasons? You can really establish the case. And so, but I still think it's also, I think it's really important to spend time before you start doing a lot of depositions, especially in a big case, to create a visual strategy and figure out, simplify the case. But also keep in mind that is your working hypothesis of the case. There sometimes things will happen during the case that either make things better or worse for you. Things like the defendant has a surveillance video or like a dash cam or surveillance video that might make your case better. It might make your case worse. You may have to refocus. The defendant had this happen 6 times before. You didn't know that. Well, that makes it a lot better. There's things you did not know then that may cause you to refine. You often don't just wholesale abandon it, but like if you made a bunch of exhibits at the very beginning, you often need to modify them before trial.
Yeah. I find that visual trial strategy enables trial lawyers to stay lighter on their feet because you can see your working hypothesis. You're absolutely right. There's precious few cases I worked on that don't have some little surprise elements that come up at various points. But when you have, it's like a survey. It's like you have a God's eye view of the case, and you can see where avenues that you've been pursuing need to be refined to bring them more in a certain direction, for instance. And you're absolutely right about deposition. I love to, when I work with firms, we create a lot of tutorials. So a lot of tutorials, again, like you're saying, teaching the facts of the case, teaching the authoritative data. When we work really hard to do that, what is the authoritative information and data, the sources that the defendant's decisions needed to be based on? When we really understand those and we know how to teach them to the jurors, then it becomes like an outline for things you want to ask the defendant. That you have very simple, plain language, because you've already done that, creating and distilling plain language for the jury. So then you can ask plain language questions. Sir, is it true that this, that, and the other? Well, yes, that's true. So then they're buying in on everything in your tutorial. So you'd have not only the authoritative sources to back up what's in the tutorial, but you have their own testimony where they say, yes, that's true.
Right. And you're going to win either way. They say, yes, that's true. Then you all agree. Or they say, no, it's not true. And then, well, what authoritative sources do you have that should back you up?
Right. That's not a good look either. So, then they're damned if they do, if they damned if they don't.
So when I've worked with you, it's been multiple days in a row. Mm-hmm. Why is it important that, like, for your process? I think you do that, whether you're doing in person Zoom, 3 or 4 days, so many hours a day, every day, as opposed to 3 hours here, 4 hours there. Let's meet again at different points of the case. Why is it important to have that focused block of days of time?
Yeah. Rodney had a phrase, and he may have been quoting someone else, but he just said, no problem can withstand the sustained critical thinking of a team. And it's that sustained critical thinking that, if you're just popping in, popping out, let's work on this. Okay, we'll see you next week. Without that sustained critical thinking, very often we'll get really close to the nub of something And well, then we move on to something else. We were just about to break through, but we don't even know that we were about to break through because we've moved on to something else, that short attention span theater that we're all living in now. But with that sustained attention, and sometimes it feels like, like in the boxing ring when the boxers kind of hang on each other because they're tired. It can feel like that in certain moments. But then because we're all working on the same problem, we're all coming at it in that sustained way, we'll break through into a new realm of simplification. I mean, it really always comes down to that. We're never breaking through into making things more complicated. We're breaking through into making things simpler, and that takes time. And it's not the way lawyers are conditioned. They're conditioned to use words in a very linear way. Okay, file this, do this, what's next? Let's move on to the next thing. But that iterative process, it's something that artists learn, that you sketch, and then you come back and you refine to get to the nub of the issue. And in visual trial strategy, it's a very important part of it. So even if you don't use a consultant like me, I highly recommend setting aside an entire day, better 2 entire days, where the team can be in a room together, preferable to Zoom, but Zoom can work too. Teams are now more dispersed, where you don't work on other stuff. And that's just like, oh, lawyers are like, I can't handle it. Yeah, you don't work on other stuff. You just work on the case. Cases benefit a lot. They get turbocharged from 1 to 2 days of really locking in, work the whole day. If that's too much, when I work with a team via Zoom, we'll work 2 hours in the morning. We'll take a break because then you can do some calls, emails. I get it. The life of a lawyer is very complex. And then we come back and we work 3 hours in the afternoon, but we're focused 5 hours a day. And then my work model is 4 days by Zoom. So we work 20 hours in a week just on these problems. And one case and one team. And the teams are just like blown away at the end of the week. There's nothing magic. It's the fact that we all focused on one case for that amount of time.
And I think the multiple days in a row makes a difference, because I think some of the best things we've come up with have been, we do our best, we kind of get to the point of frustration at the end of the day, go home, have dinner, when we traveled, we'd have dinner together. And then somehow when you wake up after sleeping on it, you have the best ideas the next day. Or you realize like something's not quite right from what we did. I think this would make it a little better. And you just get these magical, incredible ideas that next day.
That's the power of the subconscious mind. We think that our minds are just totally within our control and all of our thoughts are available to us, but we know that's not true. Some of the best ideas, the joke is that you have best ideas in the shower. And yes, you absolutely have great ideas after a good night's sleep and after breaking bread together. So yeah, when we have work sessions in person and we go out to dinner and we don't talk about the case, we talk about other things, it's amazing the gears of the subconscious mind are turning. So I highly recommend multiple days in a row. I said 1 day because sometimes firms, they just won't commit to 2 days in a row. But when I work on a case, it's multiple days in a row. And every morning after the first day together, we always start with easy kills. After breaking bread together or after a good night's sleep, it's amazing. People say, you know what? I have it. They have the breakthrough, or they see a fatal issue in what we worked on the day before. But that wasn't wasted time. Like exposing that in the calm of a work session months or even years before trial, that's when you want to expose those issues that need to be addressed, not on the eve of trial, not in the middle of trial. No meaningful surprises.
What are your thoughts on AI or artificial intelligence and what that may or may not have to do with all the visual trial strategies?
There is so much going on with AI right now, and it's a very exciting time. I'm not anti-AI. It's sort of watchful waiting right now. I see the power of these tools. I see there's a lot of excitement surrounding AI. I also see there's a lot of fear, like how powerful is this going to become? Is it going to become too powerful too fast? And just there's a feeling among trial lawyers that like, wow, things are just shifting so quickly. And they are. But I think it's had a very interesting boomerang effect for visual trial strategy. because visual trial strategy is not about the latest whiz-bang technology. It's not about our robot overlords having all the answers. It's not about some kind of new computerized technology. It's about the technology inside of our brains, which is something that was pretty much locked in place, like, depending on how you want to look at it, maybe 25,000 years ago. So it's a very old technology. Cases are decided by jurors. Jurors are not AIs. Jurors are men and women from a varied background. They're different ages. They have different education levels. They have human brains, which sometimes don't pay attention, which sometimes don't remember things, human brains that are very visually oriented. So it's a super old technology. And I'm finding that that's like very soothing to trial lawyers right now to realize that the real key to winning cases relies on an extremely old technology that we actually understand pretty well.
You know, one of the challenges that I've had is I love working with you, but you're only available so many days a year. I mean, and even if you were available, I mean, we have 10 lawyers, 100 and something cases. We could not work every case with you. So we have to learn how to do some things ourselves. How can we learn? Obviously, there is a learning by osmosis, just working with you, watching you, but are there other ways we can learn how to do better visual trial strategy?
Yes, and that is something that makes me sad, is that I am but one person, and I've already divulged my work model is one case, 1 week. Well, you can do the math on that. How many cases per year can I possibly work on? So it's to me, the analogy is like I'm planting carrots, because you know how carrots go. You plant a carrot seed, you get 1 carrot. Versus like a tomato. You plant a tomato seed, or God forbid, zucchini. You plant a zucchini seed, you get like hundreds of zucchinis. So I want to plant zucchinis in terms of visual trial strategy being a meaningful part of really every trial lawyer's case. So I created CLE courses. So at my trialstrategyacademy.com, I have a really in-depth course, 3 courses: Foundations of Liability, Liability Deep Dive, and Damages. And if you do all 3 courses together, it's 13 hours. I have exhibit templates that are just ready to use and toolkits for how to use them. I have had so many lawyers tell me that they are now using visual trial strategy. They don't need me. They don't need any kind of fancy whiz-bang fly-through technology. It's just them in their firm on the back of a napkin, and they're using visual trial strategy themselves. And it makes me really happy because I know it makes a difference.
And again, what's the website for that? We'll have a link in the show notes, but just so.
Yeah, it's trialstrategyacademy.com. And so that is my custom CLE platform.
And I know that the lawyers at my firm, we've gone through that online training, and it was really helpful. And because, just the way we've practiced law since we started working with you, I think 2018 has just changed for the better, because we're much more visual, but we also start thinking about our cases a lot further in advance. It's made a great benefit for our clients and our referral partners, and it's made our life more fun too.
Yeah. Your firm is a really great example of living visual trial strategy from the ground up. You understand that it's not just about slapping exhibits together on the eve of trial. You understand that it's a process that informs every aspect of your case development, and it shows in your work. So that's super exciting for me, and that's what I like to see, because I know the difference it makes. And just a note that my CLEs are State Bar of California approved CLEs, which a lot of states honor California State Bar CLEs, like I know New York and New Jersey and many other states. But even if you don't need the CLEs, they are chock full of real material that you can put to use today. It's not just theory, it's how to do it.
Absolutely. Well, Amy, I've enjoyed talking to you. I always learn when I'm talking to you. I've got a trial coming up in a month, and I've got so many ideas right now. And I cannot wait to work with you again here in a few months.
I'm stoked.
So thank you for coming on, and thank everyone for listening to this episode of Trial Lawyer Nation.
Thanks, Michael. It was a ton of fun.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates, insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive, plaintiff lawyer-only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our host, guest, and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.